Calling the next case, People versus Christopher Tadgerson. This is an oral argument on the application, 15 minutes per side. My understanding is that Mr. Miller, you are going to be sharing the argument, is that correct?
That is correct.
Okay. You are not Keith Clark. No. Okay, Mr. Rasusha. So 15 minutes each side. You know how to split your time, counsel. 2 minutes, a fire-free zone, which you may waive. Obviously, anytime you want to reserve for a rebuttal, you are permitted to. We just ask that you keep track and let us know.
Thank you. Thank you.
Thank you.
Good morning, Your Honors. Mike Middlestad of the State Appellate Defender's Office, appearing on behalf of Mr. Tadgerson. With me at counsel table is Aaron Bartels, who has been intimately involved with this case from the beginning. I would like to reserve 3 minutes of my time for rebuttal. So, requiring the PPCS statute to include proof of scienter is not only consistent with our longstanding presumption against strict liability offenses, but is commanded by MCL 8.9. 8.9 does more than just reaffirm our traditional preference for against strict liability offenses. It does so in a couple of ways. The first is our case law has traditionally allowed for an explicit or an implied imposition of strict liability in the statute, where the statute is silent. Not so anymore. Subsection 2 of 8.9 has replaced implied strict liability with the plainly imposes language. In other words, that says that you have to plainly impose it. We know what plainly means because it's an easily defined term based on dictionary definitions. The second is where we look to find that plain imposition language. And the first 8 or 10 words of both subsection 2 and subsection 3 tells us that. And I'll quote that. It says, if the statutory language defining the criminal offense. So that means that you have to look at the actual 4 corners of the crime defining the elements of the offense for that plainly imposes language. If you combine that with the last sentence of subsection 2, which says that just because one subsection imposes strict liability doesn't mean that you can impose strict liability on the other, with subsection 9, which says mere silence does not mean that we mean to impose strict liability, that makes the primary, if not the exclusive focus of the plainly imposes inquiry on the language of the statute defining the offense itself. Now, that's where the Court of Appeals in this case got it wrong, and that's where the Ramsdale case, whatever's left of Ramsdale, we disagree with the Ramsdale opinion, but whatever's left of Ramsdale has been superseded by this statute. Both of those cases looked outside the definition of PPCS to other sources, and both of those cases found an implied rather than a plainly imposed strict liability requirement in the PPCS statute. Plainly imposed is not a real technical term. Plainly imposed can be defined using dictionaries, and we provided a number of those definitions in our briefing there. And MCL 800-281 subsection 4 does not plainly impose strict liability. It doesn't contain any of the clear and unobstructed language imposing strict liability, nor is strict liability capable of being seen with a quick glance at subsection 4. In other words, it's just not there. There's nothing in the 4 corners of the statute defining possession of a controlled substance. Instead, you have to do what subsection 2 says not to do, and that's to sort of piece together silence in subsection 4 with an affirmative statement in subsection 2, and then an affirmative statement in the public health code. If you have to play a word puzzle like that, where you piece together things, that's not plainly imposed, and it certainly isn't based on the 4 corners of the statute defining the offense.
Counselor, can you give us an example of what that would look like to plainly impose strict liability under 8.9?
I have to concede, this was the most difficult part of my preparation for this, is coming up with language. 2 things. I think reading the legislative history of 8.9, I don't think there's much there that can be done. I think the legislature clearly intended an explicit expression of strict liability when they wanted to. But I did look at some other statutes from the civil realm that impose strict liability, and there's a dangerous dog statute that I looked at. And if they use language such as if your dog, if someone's dog injures somebody, regardless of whether that dog has ever injured somebody in the past, and regardless of whether you know it, then you are liable for the injury to the third person. I looked to the polluter pay statute, and that contains language which says something to the effect of, and I'm sorry I don't have the cites for you. If you pollute on your property and that pollution damages somebody else's property, you are liable subject to only the defenses set forth in subsection 2. So that says you're liable, and that the only way you can get out of it is to invoke one of those defenses. And if those defenses don't include a mens rea or anything with regard to state of mind, then you're strictly liable there. But I will concede that the gap between plainly imposes and explicitly imposes is not very wide, and I think that's intentionally done. And I think that's intentionally done because the legislature passed that just saw that there was far too many strict liability offenses there. And we cannot dispute that PPCS applies, or 8.9 applies to PPCS. It didn't include 800, chapter 800 in the list of exemptions from the statute. So I think Brother Counsel's argument that he shouldn't apply 8.9 just doesn't hold water there, so.
Council, you obviously asked us to follow the clear language of 8.9, but if I agree with you on your first point, I'd love to skip ahead to the second point of what scienter would apply.
Yeah.
The statute seems to very clearly say intent, knowledge, or recklessness. So
Yes.
why isn't it, the prosecutor gets to pick?
Yeah. Well, the prosecutors get to pick, this court gets to pick, and the model criminal instruction committee gets to pick there. But I think the knowledge element is appropriate here because knowledge is most consistent with our general principle that a person has to know the facts that makes his or her conduct criminal. And if you don't know that you're possessing a controlled substance, or if you don't know you're possessing anything at all, then that doesn't, that's not consistent with that principle. I think knowledge.
Does the statute allow us to get there?
The statute says you have to get there because one of the three must apply. To the extent that a element of a crime could be reasonably included, inferred to impose a mental state, then yes, you do have to get there to either intent, knowledge, or recklessness.
Why is recklessness not the floor, right? Especially, I'm looking at sub 5 of that statute that says, if a statute provides that negligence suffices, then intent and knowledge and recklessness will be sufficient. If recklessness suffices, then the other two. Why are we not reading the or the language of intent, knowledge, or recklessness to mean that any of those three would suffice, that recklessness is the floor? I understand your point that typically these type of possessory crimes, knowledge is, in other circumstances, the standard applied. But if we're following the language of this that says, I'm struggling to not read that as saying it can be recklessness or knowledge or intent.
I think that would be inconsistent with the language of the statute because it clearly says that there's got to be a mens rea, and the mens rea has to be appropriate for the circumstances of the crime. I would also submit that again, the common law gives pretty good direction on this aspect. The possessory offense requires proof of knowledge. Now, if you had a statute, and I will admit that the sort of default mens rea for crimes under the statute is recklessness, but I don't know that putting all three in one sentence means that you can only need to prove recklessness and you can prove it another way, because the statute subsection 2 actually says it must include, subsection 3 says should be read to include one of these three, intent, recklessness, or knowledge.
But it doesn't actually say that, right? It says if the mens rea could reasonably be applied, the element is established only if a person acts with intent, knowledge, or recklessness.
Yeah.
And I get, like, I think that could reasonably be implied, we're putting, I mean, and both sides have different opinions on it, but we're putting an actor in that. The prosecutor decides, the judge decides based on the nature of the crime. It just seems like a lot of work being done by a phrase that I just don't see, as opposed to saying, if it's there and there's a mens rea needs to be applied, it can be any of these three.
Yeah, I will concede this isn't probably not the clearest statute in the world, but I think having those three in sequence says that you have to pick the appropriate one for the condition,
Okay.
the circumstances of the offense there. So, and knowledge is, I believe, the appropriate mens rea for this offense. It's the appropriate mens rea that this court in Toombs and Magnet has said, is appropriate for possessory type offenses, and it's consistent with the Supreme Court decisions on the issue. With possessory offense, knowledge is the appropriate. There's also a template for it, right? We've got both the possession of a controlled substance statute, which gives us a knowledge element and gives us a jury instruction to be used, and we also have a prisoner in possession, or a jail prisoner in possession of a controlled substance crime, which reads almost identically to this offense. And there's a model jury instruction on that, which basically says the same thing, must prove knowledge. So I think that's the straightforward way of applying the statute, and that's the straightforward way of having a mens rea requirement. I could, there are other reasons why, beyond 8.9, that scienter should be read into MCL 800-231.4. The rule of lenity is there, and this court and the U.S. Supreme Court has said that the overriding theme, the theme running through all of our decisions is the rule of lenity, which is we resolve any doubts about the application of a statute against criminalizing the behavior. You also have to look at the absurd results rule of statutory construction. If you read subsection 4 to be strict liability based on the absence of a knowledge element in that section and the presence of a knowledge element in subsection 2, then subsections 1 and subsection 3 also must be read as imposing strict liability. And that will lead to a number of unintended consequences, because that would make a number of ordinary citizens, non-prisoners, unknowing felon, even though they had no way of knowing that they were doing, delivering or disposing or bringing controlled substances onto a prison grounds. I know for a fact that in all the times that I've visited a prison, at least one of those times I probably forgot and kept a prescription drug in my backpack and put that in the lockers there. That would make me liable. That would make me a felon with no defense, at least under their reading of the statute. Unless the court has any other questions, I'll reserve the balance of my time for rebuttal there.
Thank you.
Thanks.
Good morning, Your Honors, and may it please the court. My name is Jordan Miller. I am the Chief Assistant Prosecutor for Manistee County, appearing on behalf of the appellee in this matter. I do want to start by, again, recognizing Mr. Restuccia has requested 5 minutes, so I would ask the court to allow that. Our position in this case is that the court should find that MCL 8.9 does not apply to the crime of prisoner possession of contraband because MCL 800.281, specifically subsection 4, which is the subsection that Mr. Tadgerson was convicted of in this case, does plainly impose strict liability. As this court knows, in 1998, our Court of Appeals in Ramsdale held that the crime of prisoner in possession of contraband is a strict liability offense. In so doing, the court recognized some very long-standing jurisprudence and principles that not only this court, but the U.S. Supreme Court and other courts have relied upon when they engage in judicial interpretation of statutes that are at least textually silent as to the element of mens rea. And in the Ramsdale case, they not only acknowledge these principles, but they engage in that analysis to find ultimately that the statute does, that the legislature's intent was to impose strict liability because not only is there an absence of any mens rea in that subsection, but also there is a wealth of at least policy considerations. There is differing language in similar types of statutes, namely the Public Health Code, which does impose a knowledge element that the court relied upon to conclude that the legislature very clearly intended to impose strict liability. It wasn't, to use their language, it was not by accident, it was by design. And so in 2016, the legislature now purports to paint with this broad brush in saying, basically upending this jurisprudence and saying that if we didn't say it in that statute, this is what we meant, and this is how the court should interpret it. And not only does that arguably invade the province of the judiciary to engage in this type of interpretation of statutory construction, but at least as applied to this case, if you look to the language of 8.9 itself, our position is that there is room for ambiguity, there is room for finding, based on its very own terms, that you can look outside the plain terms of the statute itself. MCL 8.9 says in subsection 2 that if the statutory language defining a criminal offense does not specify any degree of culpability and plainly imposes strict criminal liability, then proof of mens rea is not required. It's sort of inherently contradictory. Two things cannot be true at the same time. One thing cannot be silent as to any mens rea, but also simultaneously plainly impose strict liability in the language of the statute. So it's sort of ambiguous in that regard. Setting that aside, what does it mean to plainly impose strict liability? That phrase is not defined in the statute. And the appellant has acknowledged that fact in its brief when it spent considerable time, considerable space defining those terms by their dictionary definitions. So our position in this matter is that MCL 8.9 is at least sufficiently ambiguous that we essentially revert back to our own long-standing jurisprudence to decide how is it, or how do we decide when a statute plainly imposes strict liability. And
Counselor, so Brother Counselor gave some examples of statutes where the legislature has done more work to show they in fact don't, there's no excuse for your lack of information or knowledge. Why isn't that a plain imposition, and why shouldn't we require that under 8.9?
yeah, I do think it's a good question. I was trying to think of myself any instances in which there are any statutes that I could think of that do plainly say that, and I can't think of any, at least off the top of my head. Short of a statute specifically saying you are guilty of this crime, it is strict liability, which I have never seen. I'm not sure how else that position could be conveyed. And so, what you have is the legislature attempting to go back and paint with this broad brush and saying, well, that's what we meant if we didn't do it sufficiently the first time. And I just don't think it passes muster specifically as it pertains to 8.9. Because again, if the phrase plainly imposes isn't sufficiently defined and it's ambiguous, then what are we left with but to look to the very same things that the Ramsdell court looked to, the very same things that this court has looked to in cases like Quinn, Toombs, Magnet. We look to legislative history. We look to similar statutes that might contain similar language but are different to glean what the legislature intended in that case. And I think if we do that in this case, we do arrive at that conclusion.
Counselor, doesn't that sort of read out our requirement to apply 8.9 though, if we're just looking to all of our prior law? Doesn't 8.9 have to mean something in this context?
I'm sorry, I couldn't quite hear you.
So if we're just looking to prior law, it feels like we're ignoring the legislature's directive in 8.9. And so how do we account for that?
Sure, and it's almost a conundrum in and of itself, because we also have this presumption in the law that the legislature is aware of our prior judicial interpretations and decisions when they pass legislation. And so one could make the argument, at least, that surely they were aware of the fact that Ramsdell was out there when they passed this legislation. Shouldn't they have specifically amended this statute? And it's our position that that is the better avenue, is to specifically amend these statutes at issue if they want them to impose strict liability. I'm not sure if that answers your question or not, Justice Thomas.
So would your position be that, are you questioning the application of 8.9 generally, or just to this specific statute?
Specifically as it pertains to 800.281. As we know, there is a subsection in 8.9 that specifically excludes its application to lots of crimes, mainly the penal code, the motor vehicle code, which are the realm in which a lot of cases have engaged in this analysis as to whether plain strict liability is imposed. But our position is that obviously that jurisprudence remains good law as it pertains to those cases. It's specific to this statute. Certainly there could be other instances in which 8.9 would supplant whatever existing jurisprudence might be out there that specifically dealt with that case or that statute. There could certainly be those instances. Our position is that specifically as it pertains to the prisoner in possession of contraband statute, that it does plainly impose strict liability, and therefore it does not, 8.9 does not apply.
Have you found support in any other state that might have a statute similar to 8.9 to support your contention that the statute is constitutionally suspect?
Constitutionally suspect, no. I will acknowledge that it is somewhat of a novel theory to put out there. It just strikes me that it is, it's a fine line that the legislature is walking when it purports to essentially take over the role of the judiciary, not by simply saying this is what we meant, but this is how you, court, should interpret this statute if the language was not clear. And so, the separation of powers is as ancient and inherent in our system of constitutional law as the very principles in the Constitution itself. And we know that the separate branches cannot exercise the authorities of other branches unless specifically delegated, and that has not been done. And so, again, at least it's our position that by attempting to tell the court this is how you must construe a statute, they are invading the province of the judiciary to do so, which is again, a long-standing tradition that courts have engaged in this type of analysis to decide, in the absence of specific textual language, how do we glean the legislature's intent. And again, it's long-standing jurisprudence.
I feel a little bit like I'm in the upside down on this. Like it's, I don't know, and maybe you could point to me to where in the statute it says, court, you have to construe it like this. Why we're normally saying, look, at the legislature says, what are the elements of a crime? What this means, we look at the words that they use, that the legislature uses. I'm struggling to see how that is, and they have said it in a lot of words in 8.9 of what they mean by strict liability, the required mens rea, absence of language doesn't mean this. I mean, I think, why is that? I'm struggling to see how that means they're telling the courts how to do something that is within the realm of the judiciary, as opposed to the legislature specifying what is within their realm of saying what the elements of a crime are, or of saying, formulating statutory law.
Yes, and I do want to be mindful of my colleague's time, but I'll attempt to answer your question. I think it's found in subsection 3, in which the statute basically says that if the language defining the element of the offense is related to knowledge or intent, or to which mens rea could reasonably be applied, does not specify or plainly impose strict liability, the element of the offense is established only if. So that is the legislature telling the court, you must then impose one of these three, only these three for that matter, which sort of touches upon the second question the court has asked us to address, is what is the mens rea that should apply in this case? And why doesn't negligence suffice, for example? Why isn't negligence included in this subsection of the statute? It's our position that perhaps negligence would be the best standard to apply when we consider the fact that prisoners specifically have fewer rights, limited rights, as long-standing precedent, and should have to take extra care not to catch themselves in this criminal statute.
Okay.
So unless there are any other questions, I would yield.
That could be difficult, though, to take extra care to not be caught in this. I mean, he might not have known what was being passed.
Sure, and to answer your question, Justice Bernstein, I think certainly you do still have to acknowledge, that there's a voluntary act. There's no question about that. You have to acknowledge knowing possession, and I think what we're talking about is whether knowledge, for example, or recklessness as to what the substance that you possessed was, is perhaps where we could find wiggle room for a more strict standard if the court does determine that 8.9 should apply.
Okay, but it's tricky because someone can just pass something and you don't necessarily have control of the fact it's being passed over to you.
Yeah, and I think in part at least, this is what the Court of Appeals was acknowledging in its footnote when they alluded to the Lehman case, where they talked about the defense of involuntariness as perhaps one way in which these very types of circumstances could be avoided and those outcomes could be avoided.
Okay.
Thank you, Your Honor.
Thank you.
Your 5 minutes is down to 3, but you talk so fast, I'm
I
sure
know,
you
I
can
was
fit
just
it
gonna
in.
feel like
say
you
that.
can
I think you
squeeze
can,
it in.
I think you can do it, Mr. Rustusha.
May it please the court, Eric Rustusha from the Attorney General's Office, appearing on behalf of the Department of Corrections as amicus. I'd like to make 2 quick points this morning. First is that the prisoner possession statute is a strict liability law, requiring only proof that the person's a prisoner and possessed the controlled substance to be guilty. 8.9 confirms this point because it's plain from the statute itself. The second is that there's a lurking constitutional claim about due process in this case, and I think this court's jurisprudence in People v. Quinn, the seminal case on strict liability, supports the constitutionality of the law, and any claim about innocent possession that Tadgerson may be advancing is addressed by this court's decision in People v. Lehman, which identifies the common law defense of involuntariness, for which the defendant would carry the burden to prove as an affirmative defense by preponderance of the evidence that his possession was involuntary, that was outside of his control. On this second point, while there's been a little briefing about the due process part and the defense, the decision below references the point expressly. Footnote 4, involuntary acts, if proved, provide a defense against the actus reus element of a crime, citing Lehman. It's an important question for corrections because of the dangerousness presented by drugs in the prisons. And this statute is an essential tool for maintaining the security and safety of the prisoners themselves and also for the corrections employees.
Counsel, so first of all, thank you for your brief. I found it very helpful. You provided lots of examples, which are very interesting and creative, the way folks obviously are trying to get past the rules. I found a lot of the examples that it seems like no matter what the mens rea would be, that it wouldn't be a very difficult threshold for you all to prove knowledge or whatever the standard may be. It seems like you have a lot of evidence, video, witnesses, all of that. Why does it matter?
Well, I think that for prosecutors, they know that in corrections that you don't really have complete control over your space. So this theory of defense, which is I didn't know it was there, is commonplace. And in fact, if you look at the Magnet case, that very description was given about the lack of knowledge and that would be a frequent offense. In Magnet, this court explained that there would be an ability to bring in witnesses to rebut those kinds of claims. Whereas in the circumstance in which contraband is found or controlled substance is found in a prisoner's area, the prosecutor knows that they have to, or if it is an element that has to be proven, that they're going to have to overcome this possibility that someone else has come in. Because the whole point of strict liability offenses is to place the burden on the person who's in the best position to prevent the thing from occurring itself. Because if you look at the other crimes relating to what Justice Thomas's question is, like, where are the other examples of this? Because the standard examples of strict liability are criminal sexual conduct in the third degree where the victim is under the age of 16, or the transport of long guns that are loaded, or felony non-support. In all of those circumstances, the language in those statutes is virtually identical. In fact, if you look at the Lehman case, the very thing that happened in the non-felony support happened with respect to this statute in an analogous way. In the felony non-support statute, refusal or neglect was pulled out of the statutory language. Here in 1982, when the legislature came in and created this statute, it used the language of possess in the face of the Controlled Substances Act, which said it had to be intentionally and knowingly or knowingly possessed. The absence of that language is an unambiguous, plain, The argument that it has to be expressed is not in 8.9. 8.9 only requires that it be plain. If you look at the other statutes that have been found to impose strict liability, the statutory framework is virtually identical to the one present here. And if you look at the statutory context, which is not legislative history, but the statutory context itself, it makes it plain that this was designed to be a strict liability
What do we
offense.
do with the rest of the statute for, the point made about the postman or attorneys who, inadvertently are a player in a scheme to get drugs in?
The concept of this is much like the airport security statute. There's a 259.80F, possessing a firearm in a sterile area of the commercial airport. If you possess it, if you do that, it's a 1-year misdemeanor. The concept here is anyone who brings in something into the facility, controlled substance or also weapons and other things, it creates that danger. So it places the burden. It's supposed to be a strict liability offense. That's the very design of the statute, because it places everybody on notice about the danger of presenting these things within, because the person that's in the best position to prevent this from occurring is the prisoner himself, to guard against things, or someone who's coming in to make sure that no one's bringing in a weapon. And the question then comes of what happens if someone who is innocent is ensnared? Justice Bernstein's question, or one of the hypotheticals about the absurd results argument, is really answered by this court's analysis in Lakine, in which it talks about the common law defense of involuntary acts, because if it's beyond your control, you can't be subject to a criminal prosecution. And I think that's what's driving the arguments of Mr. Tadgerson, is that it was brought into my cell beyond my control. Well, he has a defense. Now, it's his affirmative duty to prove, and the reason that is so critical for corrections is, to be honest, for prosecutors, they don't like prison cases. They're often reluctant to bring these cases forward, particularly if there's not a serious harm. And the idea of drug offenses are perceived to be non-dangerous. Anyone who works in corrections knows the opposite, that for corrections and the culture in which corrections operates, they are very damaging. In fact, I know we had a civil case in which someone brought an action against the Department of Corrections for failure to prevent the bringing in of drugs, because there was an overdose death, and there have been 2 other overdoses within a few days, because of the dangerousness for the prisoners themselves, the culture it creates, the violence that arises from it. It is of utmost importance. So really the question comes, I think, is once you recognize it as a strict liability offense, is its constitutionality. And that's the reason I think Quinn and Lakine are so important, because they demonstrate its constitutional validity.
Thank you, Mr. Restuccia. Any other questions? No. Thank you.
Thank you.
Mr. Millicent?
Under 8.9, there is no affirmative defense of involuntariness. If you look at subsection 1, that reads, except as otherwise provided in this section, a person is not guilty of a criminal offense committed on or after January 1st, unless both of the following apply. And A says the person's criminal liability is based on conduct that includes either a voluntary act or an omission to perform an act that the person is capable of performing. They have made voluntariness, or the lack thereof, an element of the crime. I can see a scenario where the defense would have some sort of burden of production to bring it forth, but it would still be the prosecution's burden of disproving that defense beyond a reasonable doubt, because subsection 1 says so. All of the cases cited by Mr. Restuccio that talked about silence, and we can cobble together this way of finding strict liability, all those deal with statutes that are not covered by 8.9. This is a very narrow ruling in this case, because you're not upsetting how we determine strict liability for a whole host of felony offenses. You're saying that these crimes that are covered by 8.9 must be interpreted in this way. I want to talk a little bit about the primary appellee's argument. One of the points he made was that, well, the legislature should have, in the wake of 8.9, gone and amended the PPCS statute. 2 things. Number one, if you do look, and I hesitate to go too far into the legislative history, because I've said you got to base your judgment in the reading of the statute on the plain language of it, but the legislative history does kind of explain that. And basically they said, we've gotten sloppy with our statute. There's too many of these to do on an individual basis, and so this is meant to be sort of an omnibus statute, all right, that goes across the board. They've also said that in the future, we're gonna clean this up. We will look back and clean this up in individual cases. Is that the ideal way of legislating? Absolutely not. But it is what the legislature it said, and it's what the legislature did, and it's this court's duty to follow the plain language of the statute. With regard to the separation of powers, I don't know if that the court has any questions about that, but you said it, Justice Kavanaugh, this court's duty is to figure out what the legislature meant, and 8.9 says this is what we meant. It's not anything that takes away rules of statutory construction. Rules of statutory construction are designed and set up so that this court can figure out what the legislature meant. They are explicitly saying what they meant in 8.9.
Thank you. Thank you very much.
Okay, thank you.
Time is up. Thank you, and the case will be submitted.